right, I'll call the meeting to order. Can I have a mover and seconder, please? Councillor Maude Chapman and Councillor Hanna, that the special meeting of the Council of the Township of Springwater of December 21, 2020 come to order at 2:01 p.m. All those in favor? That is carried. Due to COVID, we are taking necessary steps to limit in-person meetings. So we are tuning in virtually, all of the participants of this meeting. You can watch this meeting online at www.springwater.ca/live, or you can tune in into the YouTube channel if you're not able to watch it live by accessing it on the website. Are there any disclosure of pecuniary interests? All right, seeing none, I'll now welcome Mr. Bruce Engel and to make a presentation to us. And Joe Mullen as well is in attendance. Thank you, Mr. Mullen from Ainley. So go ahead, Mr. Engel.
Thank you, Mr. Mayor, members of council. Obviously, Mr. Mullen and staff are able to assist, but I think I got the short straw, so I get to walk you through this agreement as best I can. And I wanted to just start with a bit of background so that we have the right context for what we're doing here. And then I was going to go through the agreement schedule by schedule, just to describe what they are, because most of the agreement is schedules, and then highlight within them aspects that are particular to the mix, because there's many provisions that are sort of standard subdivision agreement things that are not different for this project. So that's what I've tried to break out, things where there's something that we've tailored to this circumstance that I wanted to call to your attention. So
Mr. Engel, for council, if there are questions as we go along, they'll raise their cards, and then I'll just interrupt and direct them to you. Okay?
That would be great. Thank you, Mr. Mayor.
Thank you.
So this subdivision was approved with several others in 2014 by the OMB. That's now the LPAT, and that was following a settlement with the township at the time. The approval, as draft approvals are, is conditional on fulfilling a whole bunch of conditions before the plan can get registered. In this case, there's over 150 of them. Most of those are routine conditions. They go all the way down to the satisfying Canada Post and non-controversial items. There are some that were tailored to this particular circumstance. The conditions were imposed by the LPAT, and those are imposed on the basis of what are called conditions that are reasonable. In this case, the arbiter of that is the LPAT, and they remain free to revise, delete, or add conditions to this draft approval. So if there is any dispute between the developer and the township, then the LPAT gets to resolve it. So that's the approach that I've taken and staff have taken to working with this agreement, is to make sure that we're fulfilling all the conditions that have been imposed and in a reasonable fashion. And that reasonable in that context means that what gets built corresponds with what was approved, that it gets built well, and that the township isn't saddled with costs associated with the development of the subdivision that should be borne by the developer. If the township seeks to do more than achieve those objectives, there is some risk that it could be characterized as being unreasonable, and the developer could run off to the LPAT and ask for relief. Wouldn't necessarily get it if we in fact can make the case that we're being reasonable, but that's kind of the context. There's no need for the township to run off to the LPAT because we hold the cards in the terms of they need township approval to go forward. But the disputes would end up at the LPAT. So with that said, I wanted to focus on two elements of this proposal first, and they came up in the previous meeting, and they are not things that show up in every subdivision. And the first is fairly minor, relating to the Street A connection to Snow Valley Road. And the second is the major piece of the external works, a water system, the water supply system, and a wastewater treatment system, and the extensive environmental assessment process, which I'm sure you've heard too much about. So starting with Street A, that has a design where the connection between the subdivision and Snow Valley Road runs over township lands. And that was part of the minutes of settlement from 2014 and was incorporated into the OMB approval. So it runs across a strip on the east side of the township public works yard and makes that connection to the public road. In the normal course, the developer owns the lands it needs and has assembled those, and then constructs all the roads and servicing under those roads, and then on registration, they dedicate the land to the township at no cost to the township. In this case, rather than paying the township or buying the land from the township, building all these things and then conveying it back to the township, the conditions of approval just require that there be compensation provided to the township for the use of those lands. So it's less procedure, but substantively, our view of it was intended to come to the same objective, which is that the township would get money's worth for those lands. And so when this came to you before, in terms of tree cutting and grading, which came to you in March and June, we didn't deal with the compensation piece because it wasn't required until now. But that nothing has changed in terms of the design of the subdivision. So we're just adding this piece to it now in terms of the stage 2 agreement, which is the dollar amount. So in coming to that, staff had reviewed various appraisals of land value in the area, including those that it had commissioned to look at cash in lieu of parkland values. And they looked at the assessed values of properties along Snow Valley Road, although those are improved properties, not vacant land, so it's harder to compare. The land in question is 23 meters wide and about 170 meters long, so just under an acre, 0.096 of an acre. And staff settled on a value of $350,000. So that's a value of about $364,000 per acre. This was a value that in staff's view was higher than the land values in that area. And they proposed it to the developer who agreed to it. And so staff didn't see any benefit to commissioning a separate appraisal for that, since the anticipation would be the result might be for a lower value. These lands are designated industrial and they're not serviced lands. So they're not, you can't compare those to, a serviced residential lot. It's just not quite the same. In addition, this portion of the township's lands had some grading issues. And so it wasn't actually used for the township works yard. And so the developers had to go in and grade that area and in order to get that street plowed through there. And in doing so, there's actually some more of the township's lands that ended up being, I think, usable if that's needed for the public works yard. But just by contrast to the $364,000 an acre down the street on the Highway 26 frontage, which I think would be probably seen as a more valuable location on Snow Valley Road, the Hasty Tract was valued at $80,000 to $85,000 an acre for unserviced lands. And in that appraisal, they go through a bunch of comparable properties to come up with that value. So it's not just the one statement in the bottom line of that appraisal. And just to give some context, my understanding is that in the township's work to come up with cash in lieu of parkland values, a partially serviced residential lot in Midhurst was valued at about $210,000 per lot for an area of 3/4 of an acre. And although these lands, the Street A lands, aren't residential and they're not partially serviced, the compensation for that Street A area, in our view, was significantly higher than even a partially serviced residential lot value in Midhurst. So it was on that basis that staff had come up with $350,000. If we went with an appraisal to nail down the value more precisely, which I guess the developer could say, well, we'd like to have it appraised and we'll pay you the appraised value, I would be concerned that that value might be well less than what's in the agreement as drafted. So that's the reason it's not supported separately by an appraisal, because those cost money and time, but you may not come up with an answer that's advantageous. And I say that not because the developer would commission the appraiser, but even if the township did. That was the history behind how that value was arrived at. And because of staff's comfort that it was a fairly significant value in the context, that's why it was left the way it was. And so that's as much information as I can provide in terms of the valuation piece for that portion. So I was going to, unless there's any questions, turn to the external services piece, which is the other major element of it. So I see a question from Councillor Cabral.
Councillor Cabral?
Thank you, Mayor Allen. After reading the letter from Geranium's legal counsel, and I'm asking you now, Mr. Engel, you're our legal counsel?
Absolutely.
For the township, okay. I guess what I'm looking at is, I understand about appraisals, but I don't think the township at any point was directed by the OMB to sell the property. It was an agreement that was likely made way back when. After looking at the OMB decision, it seemed to deal specifically with zoning, and it seems the agreement was made aside from that. I could be wrong. I don't have everything in front of me. But this, even the reference in the legal counsel from Geranium's letter referencing the valuation coming from parkland and in lieu of sidewalks and all this, I see a distinct difference between this piece of property and everything else that you've alluded to. And the reason I see it differently is because we were never under any obligation to sell it to the developer or provide a right of way until the contract was written. And there was no figure assigned to it at that time. And I think that's the part that I know I'm struggling with. I don't know about other members of council, because it puts the cart before the horse. However the evaluation came about, it should have been something that was still negotiated through council. That's my feelings on it. And I also feel that when we're looking at, 3/4 of an acre in Midhurst, I'm sure that I could find another 3/4 of an acre parcel that might be selling for a heck of a lot more than the one that you've used as an example. But this is a strategic piece of land. It's a piece of land that the developer sought and wanted and desired. And I think the normal appraisal of the property wouldn't have been taken into context. And the reason I kind of feel comfortable in saying that is because it's not alluded to in the agreement. It's just simply that we're going to provide this down the road. The problem is that I feel council is now tied to the $350,000. The other thing I'm struggling with, and this might be something that Mr. Mullen can ask about later on, but after reading the agreement and when the works were to commence and on whose authority the works were to commence, we now have an agreement before us where the internal works have spilled out onto a piece of property that they really hadn't acquired the rights to yet, because the $350,000 has not been paid, has not been agreed to by council. Yet there's a road there. So there's a lot of problems, I think, with the way this has gone forward. And the more I look at it, the less comfortable I feel about it. Last Thursday, Mr. Engel, the comment was made that this was a standard contract. Nothing unusual. Well, that may be so for those people in the development business, and certainly those in our planning department. They're the experts. But I'm not going to profess for 1 second that I'm an expert, and I like to read the things that I'm going to sign for myself. I bought my houses, lawyers recommended, here you go, Mr. Cabral, take this to the bank, you're all set to go. I didn't just sign on the dotted line and leave the office. I read that document and I asked the questions that needed to be asked. And what I'm trying to point out here is I don't think anyone who's part and partial to this right now has ever bought anything of extreme value and not read over the contract that the lawyers and everybody else, the real estate people, are saying are standard form, because there's always going to be a question. So if I do that for myself, how on earth can I approve a contract on behalf of the residents of Springwater Township that I don't feel comfortable with? And I don't feel comfortable with the process that got us to this point in time. And I think that if the $350,000 was such a wonderful idea and such a great pocket full of money, the council would have been apprised of this way back when it was first discussed. And that's the part that really is causing me so much difficulty. Not on top of that, the fact that there's a road over there that shouldn't be there right now, because there's no legal justification for them to have built it. And I'm not suggesting that it's the developer's fault. I think the process for council in being able to make informed decisions, unfortunately, seems to have fallen apart. We're supposed to get the best advice we can, and I don't think that that's happening right now. And that's why we're at this meeting. Thank you, Mayor Allen.
Thank you. So I'll look to Mr. Engel or Mr. Mullen, first of all, to have any comment with respect to the process and that went on, and then I'll turn it to maybe comment from CAO Schmidt.
Thank you, Mr. Mayor. And in respect of the negotiations and the potential key value, if I could call that of this parcel, I think that I recognize that when there's an important piece in a land assembly that somebody has, it can command a higher value in the marketplace than would otherwise be the case. But the reality in this case, and that this council is facing, is that negotiation and that treatment of the Street A lands was dealt with and approved by council in 2014. And so it became part of the subdivision approval. And the OMB said that's where the road is going to go. And so the only provision that we were left with for this current negotiation is the condition that there be reasonable compensation, or the reasonable is applied to all of the conditions, but that there be compensation provided for in this agreement. So in an effort to, we weren't, and we didn't see ourselves in a position to undermine council's settlement in 2014 or the OMB approval from 2014 and say, well, maybe you can't have a Street A, in which case you might have some leverage in today's terms. And the concern is that is unfortunately water under the bridge. If there was an effort to say, well, it should be worth much more because you can't really proceed without it. And I don't know, I haven't looked at whether they can or not, because I've been approaching it on the basis that that approval is in place for the use of those lands for that purpose. And what we were looking for was the compensation element for the value of the lands. And so the potential to say, well, I can hold out because there's no obligation for me to hand over a piece of my land, as a private landowner might do, it has to be viewed in that light, that the municipality has already agreed that Street A, and that was back in 2014, would go through there. And so that's why the values that we're presenting to you are on the basis of an assessment of what appraised values are in that area, and coming back to something that in our view was higher than that. But you're right, it may not be higher in sort of that keystone sense of you really need me piece, because we don't today have that leverage.
Mr. Mullen, anything to add to that?
Yes, Mr. Mayor, just through to Councillor Cabral and the rest of Council for a little bit of background within the details of this Street A and how it came about. In the early negotiations pre the OMB in 2012, 2013, and even right up to 2014, this Street A was actually a connection that was sort of almost a requirement of the township. The initial plans in the early days, and this is sort of the early concepts, did not have a connection there, or there wasn't a connection, but there was significant concerns from fire, from emergency services, etc., that this large of a development would be accessing off Carson Road. Right now, as you're aware, there's a construction access off Carson Road. Back in the early stages of this development, that was intended to be the actual service, the access, road access to the development. Through those negotiations pre the OMB settlement, that was the concerns that were raised with regard from the township with regard to emergency access, etc., etc. So that's a little bit of background further to what Bruce is saying with regard to how the road came about, but it definitely is identified. It is identified in all the engineering drawings, the concept plans that were in front of the board in 2014, and council of the day at 2014 would have been aware of that. But so that's a little bit additional background.
CEO Schmidt?
I have nothing further, Mr. Mayor.
Okay. Follow on, Councillor Cabral.
Thank you, Mayor Allen. I'm not debating the $350,000. I want to make that perfectly clear. It could have been $500,000 or it could have been $125,000. It's the process that got it into this agreement that I'm concerned the most about. But I also would like to point out that with respect to the context and how the agreement's already in place, maybe, I hate to say this, but maybe the developers dropped the ball in not specifying the price for this stretch of roadway when they agreed to this agreement. So, you know, in that respect, I think council actually still does have some leverage. It was not defined what the price would be. It could still be renegotiated, but I just want to make it clear the $350,000 might be a wonderful, a fair price. I do want to make one point though, with respect to the recommendation report that came before council last Thursday from staff. I reviewed that recommendation report too, and now I'm hearing from Mr. Mullen that the road has always been identified. When I reviewed that recommendation report, that piece of property next to the public works is not identified in that drawing with a street on it. As a matter of fact, the defined area for the mixed development is bordered in yellow, and then on the other side of the street, it shows the defined area for the water treatment plant. And this may be a simple oversight, but it certainly doesn't lend itself to the whole deal of this road being there. It just seems to have been omitted from there. The other point that probably should have been in that report and wasn't, and once again, it might have just been omitted by accident, or just since we're talking about the $350,000, is maybe it should have been included in that recommendation report too. So that's a couple of thoughts for now. Thank you.
Okay, Councillor Hanna.
Thank you, Mayor. But just for clarification, so I pride myself on having a very good memory of conversations, the events that take place. And I cannot remember back in 2014, this sale of this property ever coming before council. So I've spent quite a bit of time going through all the previous emails and minutes from the agenda meetings, and I still couldn't find anything. So just for clarification, can somebody confirm that this was in fact brought before council, the sale of this property or the negotiation to allow the road to go through there? I'm not saying we shouldn't allow it to go through or anything. I'm just saying I couldn't find anything to say that council had been made aware of it until our last council meeting of December the 16th.
So between Mr. Engel and Mr. Mullen and Clerk Ainsworth, do you recall more specificity around when this particular item was dealt with at council, previous term? Councilor Clerk Ainsworth?
Thank you, Mayor Allen. I will defer that to Director Spagnol as he has been reviewing that information.
Thank you, Director Spagnol. Sorry, I didn't see your smiling face there. Nice to join us.
Thank you, Mayor Allen. I think just to confirm, the draft plan of subdivision has shown the connection to Street A prior to October 2014. It was part of the mediation that occurred at that time in 2014. When you take a look at the draft plans that were considered through that process, if you look closely, there's a hatched portion which actually shows that road continuing on through the township lands and through that industrial block. It was through that process and through the design of the subdivision that it was always anticipated since 2014 that there would be a road connection with Street A going up the Snow Valley through the township property. Specifically, the condition of approval was included as something to be taking a look at down the road, but as per the draft plan subdivision, it has always been considered as a street connection over to Snow Valley and across the township lands.
Okay. Follow on, Councilor Hanna?
Thank you. So for clarification, the negotiation to sell or lease this property, however we want to word it, and the 350,000 has never come before council till December the 16th, 2020. Thank you.
I would say the negotiation part of it, no. In the agreement, no.
Okay, let's move on then, Mr. Engel, to the next part of the agreement.
Thank you, Mr. Mayor. And that is the external services and the major water supply and treatment plant and wastewater treatment plant and discharge main that have to be constructed as initial phases of those projects to support the mixed subdivision. There will be additions to those over the years as Midhurst develops, but getting them started is a major element of what we're dealing with overall in this. And the conditions of draft approval reflect the need to complete the environmental assessment work and the engineering work associated with those systems. And so a lot of the conditions you'll see are directed at that. So conditions 4 to 15 and 33 to 36 are examples of areas where they're trying to address what needs to be done in respect of that. And so there were a lot of conditions that the developers had to go through, and they couldn't proceed, including with site alteration, until they had sufficiently advanced in that process. And also a feature of that is those works are not in the township's development charges system at the moment, because the intention is that the developers would be paying for that collectively and building that on their own. And so that is what they have, we've got them to agree to, which is what the intention was. And I'll come back to that briefly later, because we have retained the option, if the township wants to go in the future with an area specific development charge in relation to those costs, then that remains an option for council. But at the moment, consistent with the approvals from 2014, the intention is developers will pay to build those plants, and it'll be at their cost and not at the township's. So with that, I wanted to get into just a little bit of the history of the subdivision agreement, which is they normally come forward to a council close to registration when most of the conditions have been satisfied. Because of the nature of these projects and because of those external works, it is proceeding in the stages that we had described before, stage 1, 2, and 3. And so it's coming to council at various times and more than once. And the registration of this plan is not around the corner. So there's a long way to go, even though we're bringing forward a subdivision agreement now. In the normal course, the practice tends to be that the subdivision agreement comes to you just about the time when the plan is ready to be registered and all the conditions are pretty close to being fulfilled. So that's a difference in this process as well. There was a question at the previous meeting in terms of timing. I think in March, at the March 8th meeting, you dealt with an agreement for tree cutting in respect of these lands, including along that Street A parcel. And then the site grading works in the stage 1 agreement came to council on June 17th. But didn't allow them to proceed further. So they couldn't do the internal servicing work and they couldn't do any of the external works. So what has been put before you is what we've deemed the stage 2 agreement, which is the full subdivision agreement, allowing them to do all the normal internal servicing works within the subdivision. It incorporates whatever was in stage 1 and adds more, but it also includes a draft of the stage 3 agreement, the external works agreement. That's about 73 pages of what you have in front of you. And that isn't ready for approval yet. It's there as a draft for your information, but it is still being completed and negotiated and will come back to council in the future. So the final point I wanted to make was that the authority that is sought from council is to allow for the agreement to be executed substantially in accordance with the draft attached. And what that allows is details to be filled in and correction of minor errors to make sure the whole piece hangs together, but it does not allow for execution by the mayor and clerk of an agreement that is substantially different from what council is addressing. And this is a normal approach to seeking council approvals for municipal agreements, including subdivision agreements. There are lots of small moving parts that need to be I's to be dotted and T's to be crossed. And so that's why that authority is sought in that form. It is not authority to go and significantly change a number or some aspect of this agreement. So with that introduction, I wanted to quickly, hopefully fairly quickly, go through the schedules and the agreement and highlight areas that are particular to this subdivision. And when I say particular, obviously all of the schedules of engineering drawings and approval status and all that are tailored specifically to each subdivision, but I don't need to go through those. There are some particular elements of this negotiation that I wanted to highlight for you so that you know that they are how they've been approached. And if you have concerns about them, we can address those. So the first 20 pages are the main body of the agreement, and it really sets up where most of the meat is, and that is in the schedules. And the intention is that that main body would appear in front of you again in the future for other mid-Hearst subdivisions without significant change to them, and that the detail will be in the schedules that follow. So on page 21, you have Schedule A, which is a list of definitions. And that simply helps define all the terms that are used throughout the agreement. So we can find them all in one place. Schedules B, 1, 2, and 3 set out the lands involved and identify the draft plan. Normally, this would be a single schedule. In this case, it's broken out because the Hickling lands were included only for the grading purposes. And there's no further work contemplated on them, but that's why it's broken out into separate schedules in this particular instance. Page 31 has schedules C1 and 2. And again, that is broken up into two pieces because it involves both the internal works and the significant external works. In most cases in the future, you would expect to see a Schedule C and not have it broken out. On page 40, you have schedules D1 and D2, again, broken up between the internal and external works. But the D2 is that 73 pages of external works agreement. And that deals with the water treatment plant, the wastewater treatment plant, and the discharge main leading to the outfall. So that in future subdivisions in Midhurst, there may well also be road improvements that are part of the external works. And those will come on as necessary, as well as potentially additions, expansions to these plants. So that's what the structure is there. And that external works agreement, as I've said, will be coming back to council for approval in the future. So having it in here is simply an indication that we're making progress with the draft. And of course, if you have any questions about it, I can address those, but we're not proposing and that anybody be bound by that agreement simply because of its inclusion in this agreement, the stage 2 agreement. That gets me quickly to page 106. Oh, sorry, there's a question.
Councillor Cabral?
Thank you, Mayor Allen. I'm just going to get back here, Mr. Engel. I'm looking at the letter that was included in the package from the Ministry of Environment and Conservation and Parks. And they are fairly clear about what can take place and what cannot take place. And when I'm looking at the Ainley's letter, identifying some of the different things that are going to be done, there's a number of questions I have on that. Do you want me to wait till the end for these, or would you prefer that I give them now?
I'm happy to hear them now, and it may be that Mr. Mullen would be best placed to deal with those. I don't have open that ministry letter, but I have a recollection of what it says. But Mr. Mullen might be able to help you with the details of what remains to be done and so on.
Go ahead, Councillor Cabral.
Yes, well, I guess you'd be turning to Table A, but actually Table B, Review of Draft Plan Conditions. I'm just curious to hear from Mr. Mullen. There's a number of items here that appear to have already taken place, contingent on council signing the agreement. But in the status, it indicates that they're already taking place and they will be adhered to retroactively, is the feeling I'm getting, to the agreement that we're being asked to sign. So I just want to know how that works. There's a number of them here too, and in particular the traffic impact assessment. I'm curious to know whether or not that included Street A in that traffic assessment, what they considered to be the volume of traffic that might be passing through Street A.
Mr. Mullen?
Yes, Mr. Mayor, through the members' council and Councillor Cabral in particular, those traffic impact study is in the process of being completed. That's currently being reviewed, or has been recently been reviewed by the Simcoe County. But that is related to the external works, and actually will form part of the external works that will be coming forth in the future in relation to the water, wastewater components as well. But there is a traffic impact study that has been prepared and is continuing to being reviewed both by Ainley and the township, but also Simcoe County for that intersection of Street A and Snow Valley Road.
Thank you. Do you have it in front of you, Mr. Mullen? Table B, item number 26. It's a pretty short read. The owner shall provide all necessary servicing easements related to each phase to the service of the property prior to final improvement of the plan or any phase thereof. And it says stage 2 subdivision agreement appropriately addresses these matters. This particular one here, I get the sense that this is one that can happen at every phase, or is this one that should be taking place post-agreement signing?
This particular one, so that number, sorry, Mr. Mayor, through to Councillor Cabral, this particular one is one that would be relating to that specific, in this particular case, that particular access onto Snow Valley Road, and so it is addressed in the agreement that's in front of us, with that draft plan condition already allowing for it, and really the only outstanding item being the compensation, and that is currently addressed in the agreement, obviously subject to your acceptance and approval.
Right. Okay, thank you. And number 34 starts off with the line prior to any site alteration or final improvement. And it speaks about completing engineering designs for the wastewater transportation infrastructure identified in phase 3 and 4 of the municipal class environmental assessment for water, wastewater, and transportation infrastructure. This here just leads me back to Street A, that it's already been built. And I'm reading this, and once again, it seems that this took place before the agreement was in place. So can you further enlighten us on how that happened? Or maybe you can enlighten us on how our engineering firm and our planning department let that road get built on property that really they didn't have and weren't authorized to build on yet.
Mr. Mayor, Mr. Engel may be able to discuss some of the legalities of it, but Mr. Mayor, through the council and Councillor Cabral in particular, the issue of Street A being a future road allowance from an engineering perspective was addressed via the draft plan conditions. It's clearly identified in the engineering drawings that are associated with the development that this will be the connection into this first stage of the development, the main access. Ultimately, obviously, there'll be accesses to Carson Road, etc. So that's from the legalities of how it's there, is that it's identified initially as a draft plan condition, and then obviously the outstanding component is the compensation, which Mr. Engel has touched upon and can re-clarify for us if necessary. But from an engineering and from a, I guess, perspective, is that it is identified as a draft plan condition. It is clearly outlined on the engineering drawings that we have reviewed in detail. The county has reviewed those drawings, accessing Simcoe or Snow Valley Road there, and that traffic impact study that's being completed and in the works obviously can addresses that as well. Hopefully that clarifies.
Sorry, Mr. Mullen. I thought you'd finished. Director Spagnell, do you have anything to add to that?
Thank you, Mayor Allen. Through to Councillor Cabral. The matter of Street A has also been brought up in previous reports in 2020 as well. The Street A connection and works associated with Street A with respect to tree clearing was referenced in March of 2020. The prospect, or but the planning that has gone into Street A connecting with Snow Valley has also been referenced in an information report as of June 3rd, 2020. And then again, in addition to that, again, I think it's important to note that the connection to Street A has been the topic of discussion through, or had been part of the topic of discussion through the mediation session, as which was stated by Mr. Mullen back in 2014 as to provide access to the south as well for emergency service purposes. So the prospect of the item of Street A connecting to Snow Valley has been in the planning works and has been identified through various reports along the way, including at least 2 reports this year. The one report with respect to the execution to allow for tree clearing required authorization from council. It was specifically referenced there as well. So from staff's perspective, the planning that's gone into Street A has not been an oversight. It's something that has been stated when we brought it forward for executions to allow for works to occur on the township lands.
Follow up, Mayor Allen?
Go ahead, Councillor Cabral.
Thank you. Just wanted to, I'm not suggesting Street A shouldn't be there. Okay, that's not the point I'm trying to make here. The point I'm trying to make here, and even when we talk about the works for tree cutting at council, they were internal works, to which my way of thinking would mean internal to the property of the mixed developers themselves, not property that's going to be turned over to them as an easement, or property which they may be acquiring rights to based on an amount of money that's going to be paid to council. This question here I'd like to direct to Mr. Engel. If someone were to build a building and they hadn't paid for it yet and hadn't signed the agreement would you recommend to them that they allow the builder to commence construction on that site? Because that's what's happened here, in my way of thinking. So I'm just putting it right to you in that context.
Well,
Mr. Mayor, the March tree clearing report does identify on page 3 that the extent of tree clearing consists of an area of approximately 1 hectare. And this includes existing hedgerows and a wooded area that's located on a township block next to the Public Works yard and which is planned as Street A to the subdivision. And so that when that came before council in March, that was identified as being a part of the approval that staff was putting in front of council, and it was approved by council. So then the grading works that were authorized by council in June would included the grading preliminary to setting up Street A. And I don't know the details of construction access. That may be for Director Spagnol, but my understanding is that there were grading works on that Street A as well, and that was addressed by the Stage 1 agreement that was approved by council in June, and that they haven't proceeded past that to install servicing and actually build the road in its final form. I'm not sure if they're using that as a construction access or not. That's I can't answer that question, but my understanding is they've only been doing on those lands what council had authorized. And in terms of the question of would I let them come on my lands if they hadn't paid for them yet, that in my view is the structure of what was set up and approved in 2014. That authorization to use that portion of the township lands was agreed to by the township in 2014. And this council, in my view, isn't really in a position to not honor that unless there is some reason to seek to revise and change the draft plan and the conditions of that, in which case we could go to the LPAT and say, this plan needs to change if there's some compelling reason to do that. And the LPAT would listen to what those arguments or concerns are. And the question of value is something which, if that is to be paid upon approval, upon execution of this agreement, and the amount has been identified as something that staff had recommended to this council. If council was of a view saying, well, try and get something else, then that's a direction that can be given, keeping in mind, of course, that the LPAT ends up having the potential of answering and telling us how much it is. So if the developer really doesn't like it, unfortunately, we're not the final call on that point if it comes to that. And then obviously none of us seek to have that because we're trying to work within the parameters we have, but that's something certainly council is free to direct.
Thank you, Mr. Engel.
Councillor Moore?
Yep.
Thank you, Mayor Allen. I think the part of the concern too is that we have been part of conversations when purchasing, say, the Hasty Tract, and part of those negotiations, and then this time we weren't, so it's causing some concern. The second thing is, for this agreement, if the external works is a draft, why does it have to be in there? And I apologize if you've explained that to me already, but why would not it be a second document separate from this one and then not be quite so cumbersome? Thanks.
Mr. Engel?
Thank you, Mr. Mayor. I think the purpose of having it in there as a draft is to demonstrate publicly and to council to be an indication that we're not racing ahead with the internal works and the approval of a plan of subdivision when nothing's been done on the externals, right? That there's been no progress made there. There's been a significant degree of progress made in terms of the design and the approach to those external works, and that's reflected by this draft agreement. And although it's not ready for execution, I think it's important for council to understand and the public to understand that there's been a lot of progress on that side, because there's no sense of going ahead with the subdivision if there's never going to be the external infrastructure to support it. And so that's the reason that we've thought it was appropriate to include it.
Follow on?
Thank you, Mayor Allen. Mr. Engel, we sit in on the development meetings monthly, and I know from those conversations that they are planning full steam ahead to proceed with the external works as soon as possible. So how far in the future am I looking to approve an external works document? So this draft doesn't give them any permissions, but how far out am I looking to finally approve for them to move forward with that project?
Mr. Engel?
Thank you, Mr. Mayor. Well, if you asked the developers, it would have been months ago, as with this agreement. And we have been, putting the brakes on because there's things that have to be resolved, and there's, we have to negotiate things to our satisfaction as your lawyer and staff, and then bring it to council so that you can decide whether to approve it or not. Until we're satisfied that it's in a shape to even bring to you, we don't put it on, have it put on council's agenda. So Mr. Mullen may have a better sense of the engineering work that still needs to be done to get to that point. And then that has to be also reflected in the costing, the engineering costs for all of those elements of the plant. And then the appropriate securities that have to be provided in respect of those costs. That all has to be built into the agreement. There's timelines that are in that agreement in the draft that had been proposed to the township. You'll see if you go back into them, they're no longer accurate, and they would need to be updated because they were overly optimistic. And so, we will ask the developer for new timelines that are more in keeping with where we stand now. So I can't answer that in terms of whether it would come forward to you in January, February, or March. I'm guessing that that's the time frame, but Mr. Mullen may have a better sense of that.
Any further comment, Mr. Mullen?
Sure, Mr. Mayor, through to Councillor Moore. Basically, with regard to those external works, there have been significant works relating to the engineering being completed to date. We have reviewed 2 comprehensive submissions of both the water and the wastewater and the effluent pipe outfall. So those have gone through extensive reviews. They have already submitted for their Minister of the Environment approvals back in, I believe, September, late August, early September. So Mr. Engel's timeline of probably over the winter is probably not far off. I know the developer will be keen. Again, that would be their desire to move forward with these works, the external works that is, that's not in front of you this evening or this afternoon. They would probably be keen to move forward with those in the, post-winter time, i.e. early spring, late winter, early spring would be their timeline. Right now, from an engineering perspective, we've been through those comprehensive reviews and the engineering drawings, and they are getting close to being in that generally acceptable. From that perspective, the securities will obviously be another item that Mr. Engel has touched upon, but there has been some work done on that. There'll need to be some further, clarifications provided, but again, that would be more information that would continue to be developing over the coming weeks and a few months.
Follow on, Councillor Moore.
Thank you. So just to be clear, this contract or this agreement does not include the external works, and you're going to bring forward another agreement for the external works before they can start. So I guess I'm just still a bit confused as why it's in here, but as long as I understand that there will be another agreement coming forward.
Yes, to you, Mr. Mayor, Councillor Moore, that stage 3 agreement will come back to council. It will look, because it's 73 pages, most of them won't change all that much, but there's lots of detail and important work. There's sign-offs from the MTO in terms of the discharge main running along provincial rights of way. And some of those details, we need to be satisfied that the developer has got that organized. It's not within our control, it's not our land. but they have to have those in place. And so we can then bring a completed agreement to you for your approval. But right now, you're not binding yourself
Anything.
to that stage of it at all.
Thank you.
CEO Schmidt?
Thank you, Mr. Mayor. Through you to members of council, just to be clear, based on that question, there is work planned to be done through this agreement on the utility campus. So the property that houses the water and wastewater plant, there is through this agreement, there would be grading completed and servicing done on that piece of property. But the construction of the infrastructure, the water and wastewater treatment plant and/or the water plant cannot proceed until the stage 3 external works agreement comes to council for approval. But there is, through this agreement that you have today, there is works contemplated. Again, more of the tree clearing and the grading piece on the treatment plant or the utility campus, if you will. Just want to make sure you're clear that if you approve tonight, there will be some works on that property.
Okay, Mr. Engel, proceed, please.
Thank you, Mr. Mayor, and thank you, Mr. Schmidt, for that correction. I apologize for that oversight, but yes, that preliminary non-construction piece of it is built into this agreement, but it doesn't allow the actual plants to get underway. So I had left off at page 106, which was Schedule E, which is financial payments. And that largely deals with recognition the developer is obliged to pay things that they normally are obliged to pay. But it also covers the cost of administering the agreement, registering it, costs of the consultants, and so on. And the particular aspects that are touched on for this schedule and for this subdivision is the full-time project coordinator and reimbursement of the township's costs to have that brought on. And you'll find that in section E1 on page 106. And then the $350,000 that we've discussed already today, and that's in E8 on page 107. So those are the two things to highlight in respect of Schedule E. So Schedule F on page 108 deals with the posting of securities and says that securities must be in the form of cash, certified check, or letter of credit. You'll see on page 108, section F2 authorizes the township to accept or reject alternative methods of providing securities. This does not require the township to accept an alternative. It simply leaves open that potential, but it clearly sets out in section F1 what the acceptable forms of security are. So I just wanted to highlight that, and that's within the township's control. Sorry, I thought there was a question. On page 112, we have Schedule G, and that is just the treatment of securities. As works progress and they hit certain milestones, those securities can be reduced, and that's in the normal course, and there's nothing special about that for this subdivision agreement. Page 115 has Schedule H, which sets out the developer's obligations in respect of costs. And essentially it says the developer has to pay for all the costs and reimburse the township should it incur any costs. The particular piece of this one for Midhurst is the requirement to have the cost sharing agreement with other Midhurst developers. And that's in H1 on page 115. And that's consistent with one of the conditions of draft approval. Schedule I sets out an obligation of the developer to indemnify the township for claims, liabilities, including environmental claims and so on. And again, nothing particular tailored to this subdivision in that section. Schedule J on page 121 sets out conditions for the issuance of building permits, and then also occupancy and use of the units. And as one would expect in a normal subdivision, you can't get building permits until the municipality is satisfied that the water and sewer systems have capacity to service the homes being built. In this case, in many cases, that would be existing systems that the development is just tapping into. And so what's particular in this case, obviously, is those external plants need to be built from scratch. And so it has the same requirement that they have to have water and sewer capacity prior to building permits being issued. But, obviously there's no need for a developer to build or a builder to build houses months before those sewage plants are completed. But it's also, there's no need to have those plants completed and sitting there without any houses available to connect to them. So you'll see that on page 121 in section J1A, there is the potential for the township to agree to what I'll call an overlap. That if those external plants are nearing completion and are doing well, and because they're a long build, they take a long time to get those things done, and there's lots of potential delays in there, and the developer may be more optimistic than realistic for sometimes in those pieces, not through any fault of their own necessarily, but it happens. But if we're getting near the end of those, and with Mr. Mullen's assistance and staff's review of it, if there is a comfort level at the township, then they could allow for building permits to be issued prior to the completion, prior to actually turning on those plants. So that houses which might take 5 or 6 months to build could get underway at the same time as the final pieces of those external works are being constructed. That's not authorized by council today, but you're authorizing an agreement that would allow that to be looked at in the future, because we don't know the circumstances of how challenging these things are to build and how much progress they've made. So we can't really define any overlap today. The developer has asked for the permission to go ahead and do that, and we weren't comfortable with doing that, but we did have in there the potential for them to ask for it and for council or the township to consider that. And so that's something that, again, if it came forward, it's built into the agreement, but it would be something that would come back to council to say they've asked for this, and for these reasons we are satisfied or not satisfied with it, and then council can make that decision. So that's one piece that I wanted to highlight for you as a potential to allow for some overlap in the completion of both sides of this equation.
Question from Councillor Moore.
Thank you, Mayor Allen. So to Mr. Mullen, when I've had conversations with Geranium, the timeline that they throw around a little bit is selling homes in the spring for move-in dates 1 year out from that. So my question is, how long would it take to build this water treatment plant then? Because it seems like they would have to be starting at the same time as that they're actually selling homes and not building homes.
I'll direct that to Mr. Mullen.
Sure. Thank you, Mr. Mayor. Through to Councillor Moore. The developer, those timelines are sort of what they want to obviously ideally meet with. Right now, for example, they're out to tender with their water plant and their wastewater facilities. So they're tendering that themselves as we speak. That was going to be happening sort of over December into January. That sort of ties in with when we talked a few moments ago about coming back at some point in the spring over the next few months to look at actual construction proceeding. They would then start construction of the water and the wastewater facility. Let's assume at some point late winter, early spring. There's approximately between 9 and 12 months of a construction period that would be associated with those works, such that would be tying in with that other timeline of house closings in early 2022.
Okay. Continue, Mr. Engel.
Thank you, Mr. Mayor. The next 4 schedules don't have any specific tailoring for mix, so I'll touch on them lightly, but I'm happy to answer questions about them. So Schedule K sets out a variety of requirements the developer must meet, like paying their contractors, keeping roads clean, repairing damage to municipal facilities, street numbering, names, and very much routine subdivision related aspects. Schedule L has been left blank in this case. That's special conditions, and we already have like the external works agreement and so on that addresses those. So they weren't put in, anything was not put into this agreement for that purpose. Schedule M deals with a few requirements of notice to the township and the ability of the township to stop works in certain circumstances. And again, there's nothing particular to the mixed subdivision in that schedule. Schedule N deals with the process of the township accepting works and assuming municipal works internal to the subdivision. These are the ones they'll be constructing. So this is the term substantial completion and final completion and the warranty period that follows final completion. And so that if the municipal works have been proven to be satisfactory during that warranty period, then the township would then assume them, which means ownership and responsibility for them. So the basic rule is they design it well, and that design is reviewed first, then they build it, and that build is inspected. But even then, that's not enough assurance because things happen. And so usually once they're completed, there's a 2-year wait period to see if the roads slump or something unexpected happens, in which case the developer's on the hook for that. Again, that's all in the normal course for these type of agreements, and nothing particular to mix. Schedule O deals with insurance provisions, and this is liability insurance for personal injury, death, or property damage. And it's principally designed so that the developer, the township is protected in the sense of twofold. One is the developer has their own insurance so that someone who's injured doesn't have to look to the township, but it also specifically provides that the township is protected by that policy. And that's got a policy limit of $5 million, and that applies to the general subdivision work. Sorry, I see there's a question.
Go ahead. Councillor, show the card, please.
Councillor
Brown?
Hanna had his card up.
Oh, sorry, Councillor Hanna.
Well, thank you, Mayor. I put it down too soon. I apologize. Mr. Engel, just going back to your statement about the insurance to liability for Springwater Township. There's, I'm sorry, I got so many pages of notes here, but I don't have the document up. I think it's Schedule O, insurance. It says on page 6, the last sentence is to the effect that the developer will provide financial securities, fees, and insurance, and a letter of indemnifying. Is that there to protect? And it's the same question I had, I guess, on the previous statement. It says Schedule 1 implementation. It talks about insurance there. Is that the same as you're talking about now? To identify the township to be protected in case of liability suits or injuries?
Right, and so yes, thank you through you, Mr. Mayor. The requirement to have insurance means that there's a, you know, they're the ones who do something wrong when they're doing one of these projects, and so just the presence of insurance alone lessens the likelihood that the township and therefore its insurer would get called upon in terms of a liability claim. When somebody's desperate because they've been injured, they'll look to any pocket, and if the developer has no insurance, then the township would get appointed to. But this goes further and requires that the township be named in that policy by the developer, and so that the township is specifically protected, and that that protection doesn't diminish simply because the township is named.
Thank you.
Councillor Cabral.
Thank you, Mayor Allen. One of my concerns from Wednesday was the level of insurance that was going to be, excuse me, provided. And I did reach out to our CAO to get some information on what the township carried. And given that township has actually sent a letter And I think we're looking to make a deputation, if it hasn't already occurred, with respect to some of the lawsuits that have come forward that really don't have much to do with township, yet we're still named within them. So that comes to mind. The other thing that comes to mind now is, given the normal situation where that particular road would have been owned by the developer and not owned by the township, given that it's going to remain in township's hands, when we're talking about this liability insurance, there's still a potential then, I think, for something to happen on that particular piece of property where the township may still be held jointly responsible or jointly liable. So my concern here is based on what the township holds for liability insurance, and also that this here agreement does permit external activities to take place now as well, and access to that property. Is this sufficient insurance? And I'm just going to ask our CAO if it's possible for him to just bring council members up to speed on what the liability policies we have in place, what the limits are, versus what the developer has in place. It's a huge development, and I just want to ensure that Springwater Township's best interests are once again the focal point of our conversation.
CAO Schmidt?
Thank you, Mr. Mayor, through you to members of council. So the township currently holds a policy, general liability policy, that in the amount of $10 million as a base for any incidents that may occur in the township. But in addition to that, we also hold what's called an excess liability coverage, which gives us another $40 million. So the actual aggregate amount that the township carries for all of our general liability is up to $50 million. And typically suits that we see come to us is accidents that are happening on township roads where people, and or actually not on township roads too, county roads, and or, to be quite honest with you, we've been named in suits, individuals jumping off the bridge in Wasaga Beach, and we've been named in those suits too. So we're named in quite a few different suits. So to Councillor Cabral's comments, we have gone to our MPP and the province to seek further clarification. It's not just us; it's on that basis where should we be named, and is it appropriate that we're named in suits that have nothing to do with the township? So maybe I'll leave it at that. And as for the standard clauses, when we do our construction projects, we do typically have a $5 million liability requirement in our construction of roads, and or the Elmville lift station, for example, would likely be in the magnitude of about $5 million is what we ask for. So these limits are in kind of the ballpark of what we've seen, but maybe I'll hand things over to Mr. Engel to comment further on that.
Mr. Engel?
Thank you, Mr. Mayor. And I just was about to point out that, and this had come up in our last meeting, that you'll see in the draft external works agreement on page 58, you don't have to look it up now, but there is a policy limit for insurance identified there for $10 million. And that was identified because of the nature of the external works as being much more complicated and challenging projects, that the potential for a larger liability was felt that having a $10 million limit on the policy in respect of those works. Again, that's not, that's coming to you in the future, but that's what's being proposed in terms of the draft right now.
Follow on?
Thank you, Mayor Allen. Maybe Mr. Mullen is best to answer this one. Once again, on the liability aspect of it, I do envision, given the proximity to the subdivision itself and where the new wastewater treatment plant is going to be located, that the developers will be utilizing that Street A to gain access back and forth across Snow Valley. Would I be right in assuming that?
Mr. Mayor, through to Councillor Cabell, the predominant access to the development for construction is actually off Carson Road. They will and have just recently asked to bring in their heavy equipment for the site servicing component, i.e. the component coming up in the future, to bring that off Snow Valley Road just for access, which is actually a benefit. It keeps that large, heavy heavy duty equipment off Carson Road, but the construction access for day-to-day purposes during the next number of months or most of 2021, construction of the internal subdivision is intended to be off Carson Road. That's not to say there won't be obviously the occasional access off Street A, through Street A onto Snow Valley Road, but the predominant access is still intended to be Carson Road access.
Thank you.
Go ahead, Mr. Engel.
Thank you, Mr. Mayor. In terms of the next item is on page 158, and that's Schedule P, which is the lands that the developer is to convey to the township for such things as roads within the plan of subdivision, parkland, environmental preservation areas, stormwater management facilities. There's only one thing I wanted to highlight, which is on page 160, and that is one of those dotting of I's and crossing of T's. To avoid a really deep sewer issue and to avoid a pumping station within that plan of subdivision, the township pushed the developer to find a separate solution that would avoid doing that. And so we encouraged them to find an easement across some of the industrial lands to the west of the public works yard to bring their sewer out and across to the plant. And so there's an easement that they've secured. It's going to come from the current owner directly to the township, and it's going to be done by means of a reference plan, which Mr. Mullen's office has reviewed and approved. But what we don't have is the actual number of the plan, the actual registration of it. That hasn't come through yet. So that's a piece that we would complete. We know what it is and we know where it is. And it solves some things that the township was unhappy with the previous iteration of the plans, because it avoids a very deep sewer coming through, and it avoids, the original proposal was for a pumping station, and we wanted to not have that. So that's just one detail that I wanted to highlight. So that's on page 160. Schedule Q, again, there's nothing tailored to this subdivision particularly, but most of the plan of subdivision or the subdivision agreement deals with the developer and what they have to build and so on now. This is actually a schedule that deals with and is focused on the homeowners in the future. So this is where there's a bunch of covenants saying, don't block up the catch basins, don't mess around with the curb cuts, don't change the grading and on your lots, don't dig up your lots and that sort of thing. And so it gives the township the tools to enforce that in the long term. So the subdivision stays the way it was intended to stay. So it's most of the time we think of subdivision agreements as dealing with the developer, but there are some provisions that actually deal with the subsequent owners and are important for your enforcement over the long term. Schedule R on page 164 has a bunch of warning clauses and notices that are required, and some of those were identified from the conditions of draft approval, I believe. But things such as lighting in a park. If you're going to have lighting at night in a park, then there's a warning clause that people who might buy a lot beside the park would know that that's what comes with buying a lot beside the park. So they're less likely to complain. You, as I'm sure you're aware, get complaints anyway, but it makes it a little easier for you to deal with them if people at least have had notice of them. So there's a whole series of those in Schedule R. Again, none tailored particularly to the mixed subdivision. Schedule S is the last one where I have something particular, and that deals with development charges and connection fees. It doesn't actually spell out what they are for the developer. It just is a recognition by the developer that they have to pay them all, because the time when they actually come forward to pay them, they may actually be different because the township bylaws have escalation clauses in them, or you might change your bylaw. So that's what that schedule just identifies. Within it, in section S3 on page 167, it leaves open this potential that I identified earlier of an area-specific development charge, if the council chose to go that way in the future. And that's to bring the external works into your development charges and then make all the developers contribute towards it through a development charge, rather than this way, which we're proceeding with now, which is where they're all left out and the developers have to pay for it all pursuant to their own agreements. That's an option, and it's really something that council might consider for cost contribution by the developers who might get approved in the future, but aren't part of this initial group that got approved in 2014, so that there's an equitable mechanism for cost sharing amongst them. And so that's one of the tools that isn't ruled out, and we wanted to make sure that that possibility was recognized by this developer as we go into this agreement. Schedule T, and you'll be thankful I'm almost done, is simply a surveyor certificate, and it confirms all of the lot dimensions so that the subdivision is laid out the way it was supposed to be and the way it was proposed and approved, and to allow for confirmation that there's compliance with the individual lot zoning requirements for frontage and lot area. And Schedule U is simply for convenience, and it lists the conditions of draft approval. The conditions of draft approval exist on their own, but it's helpful to have them at hand. And so that's simply what that does. So that completes my review. I'm happy to answer any other questions, more general nature.
Councillor Hannah?
Thank you, Mayor, and I want to thank staff and Mr. Engel and Mr. Mullen for taking the time to come to this meeting today. I know we didn't want to approve, or we had concerns about approving the agreement because there was things we didn't understand in it. Not that we didn't want it to move forward, we just didn't understand the things. And I understand more now than I did last Wednesday, but I still have two areas. If I could just ask two questions, please. On page 17, item 32, it says no fettering. When I first read that, I got the impression that whatever this council decides on and agrees to, we can't bind future councils to that. Am I interpreting that incorrectly? And then I'll ask my second question.
Mr. Engel?
I'm just looking for that clause, but the typical no fettering clause is that the municipal council, you can't contract away your Planning Act obligations. So when an application comes in front of you for rezoning, you can't have made a prior, agreement or contract with someone to approve or not approve zoning. You have to wear your planning approvals hat and independently come to that determination. So that's why non-fettering clauses are put in. It's so that the developer recognizes that simply because you've entered into an agreement doesn't mean that you don't have a free hand to make decisions that you're required to make independently in the future. So that's what a non-fettering clause is for. And I guess it comes from horses originally, if I understand the history of fettering, but it's so you're not constrained, because you're not legally allowed to enter into a contract to, approve a plan of subdivision or something of that sort prior to having the public process that's involved when it comes in front of you.
Councillor Hannah?
Well, thank you. Well, just on that same question, I still find it confusing. It sounds to me like we're going to approve something. We're going to be binding this council, and how can the developer proceed if they're not under the if they can't trust the future councils won't change it, I guess is how I interpret it. And I found that as one of the things I didn't understand in this approved agreement.
Councillor, Mr. Engel?
Thank you, Mr. Mayor. If there are future matters that come before you, and you may shake your head a little bit, because there's times when I or Mr. Custer might come in front of you and say that die is cast, and this council's not free to change it. But if there's something they look for that is a change that is comes forward under the Planning Act that they've applied for, it's not to be taken that you've already pre-approved that. Now they already have approvals from 2014, and so we are obliged to honor those. But if there's something new that they're looking for, then you aren't allowed in this contract to say, I've already approved that. And so they have to accept that uncertainty, but that's just built into our system and the law under the Planning Act.
Thank you, Mayor. I do find it confusing, but I understand what you're saying. My next question, and I'll make it my last one, and is on page 50, part 2, and it's in 2.1.1 and 2.1.2, and it talks about information reports and decision making. 2.1.1 says responsibility for administering agreements, the Director of Public Works and our engineer. And then it talks about information, and I just want to make sure that I understand that if there's routine decisions that have to be made with our building department or our works department and planning department and our engineer, that council will be made aware of these, because it does say information reports. But at what point would council be asked to vote on any changes that the Director of Planning and the engineer might be making?
Mr. Engel?
Thank you, Mr. Mayor. And that is, so what council's direction would be, and this is in that future external works agreement, but as that, let's assume that for a moment that this is in the future and we've approved that with those clauses, that those clauses would say that the day-to-day running of the various approvals and stages and pieces as in the ordinary course of construction would be dealt with at a staff level. It wouldn't rise up to council. But when staff see something that is being pursued that is outside the normal course of the approval that you've given and the plans that you had that were included in what you had approved, they would then not have that delegated authority, and that they would bring that back to council saying they're asking us to, change this part of the plant or do something, and here's the significance of it. And this is why it's not in the normal course, and make a recommendation to you. And then you would be able to make a decision on it. So that it's an attempt to try and create that division so that you're not having to deal with every decision, because there's a lot of decisions that are essentially trivial, but they're from council's perspective, but at a staff level, they need to be done. We can't just turn a blind eye to it. But if there's something that is out of the ordinary course of that, basically what you thought you were approving should happen, and it shouldn't come back to council. If something is going to move away from that, such that staff says this is not what council had in front of them, this is out of the normal course, it would then have to come back to council for your further approval.
Follow on, Councillor Hanna?
Thank you, Mayor. And the reason I asked the question, so we won't be having discussions like we've been having with reference to Street A. So again, I just want to thank staff and Mr. Engel and Mr. Mullen and whoever else was involved in moving this forward, taking the time to have the meeting today. Thank you.
Thank you. Councillor Moore?
Thank you, Mayor Allen. I have two questions. I'd like to go back to Mr. Mullen if I could. Mr. Mullen, when we're talking about truck traffic, and you mentioned that most of the truck traffic would be coming off of Carson Road, not using Street A. But in previous conversations, we're talking about allowing them to move their dirt, say, over to the lands that they're donating to us to fill it, to bring it to grade. And wouldn't it make more sense then for them to be using Street A, or are we going to put something in place that they actually have to come out Carson Road down Wilson and use that as a truck route? Because I can envision many hundreds of truckloads.
Yeah.
Is that Mr. Mullen?
I think so, yes. Mr. Mayor, through to Councillor Moore.
Thank you.
There has been some discussion, as you recall, earlier this 2020, late 2019, about the hauling off of that excess material. And at the time, the developer agreed to sort of pause that until the future, and at which time we would then bring it back to the table. So that is not contemplated through this agreement at this point in time. That's still in the future. That is something we will have to look at. What is the best option for getting that out of there, the most direct option. I believe, if memory serves right, they had 2, maybe even 3 locations they wanted to sell it to. But that's something we would look at again to minimize, as you say, the truck traffic on what I would say Carson Road, which is not necessarily a major truck route, whereas Snow Valley Road, Highway 26, etc., is more of that access. So that's something we will have to look at again. But again, that would be reevaluated by staff when it does come forth by the developer in the future, whether that be at some point in 2021, which is later 2021, which is what I seem to recall. They had put a pause on it for 1 year. We would reevaluate that again, and in conjunction with the county, the township, and obviously yourself.
Follow on?
Okay, I'm going to leave that for now. I know that we've talked about that, Mayor, in our meetings, but I'll leave that up to you. My second question, though, is to CAO Schmidt. The $350,000 that we will be getting for Street A, when will that come up for conversation as to what council will decide to do with that money?
CEO Schmidt.
Thank you, Mr. Mayor. Through you to Councillor Moore. If it's on the table tonight, if you will. If council has any ideas as to where they like those dollars allocated, I guess we could take that now, or subject to council moving forward with the agreement tonight, it's something that we could bring forward to council in a future staff report, providing particular options and or if council has other thoughts, which I'm sure some may. Again, we're in council's hands. I do just want to say one thing though. I just caution council, not regarding this matter, but regarding some other conversation that just happened regarding conversations that happen in closed session. Just to be careful about having those conversations in an open environment. That's all.
Councillor Moore.
Thank you. So if the conversation then for the money is open right now, I'm certainly going to say that I would like to see the money stay in Ward 4 because that's where the inconvenience and construction is happening, and certainly would like to say that I can envision a rink house at the Grenfell Hall, and I would like to at least put that proposal forward, or somebody would like to talk about alternatives, but that's certainly what I'd like to see happen with the money.
Okay, thank you. Councillor Cabral.
Thank you, Mayor Allen. I just want to actually thank Mr. Mullen and Mr. Engel and staff as well. I think if we had have gone through this process prior to last Wednesday's meeting, we probably may have been able to deal with everything at that particular time. I'm not going to simply assume that the $350,000 is written in stone. As a matter of fact, I was prepared to come forward and ask that staff be asked to go back and renegotiate that particular one. But I think our hands are fairly well tied by what's transpired thus far. So I don't think council per se would have an appetite to do that. I do want to speak to a couple of things that kind of lead me to believe that there might have been some thought or whatever, but the perception people might get is that when this came before council on Wednesday, that I hate to use the term, it might have been a slam dunk, and that didn't happen. And the only reason I say this is given the timing of the letters that came to Springwater Township to put this on the agenda for the 16th, and given the time that this process has been ongoing, and then reading the letter that was provided to us by Geranium's legal counsel, where they allude to the fact that they wanted to move this meeting up so that they might be able to have council decide, make a decision on it, so it didn't impact them as far as their works and scheduling and all this, which they were prepared to go ahead with. It just leads me to think that given it's a business decision, that I would suggest that maybe Geranium should have sent that letter to have it put on the agenda much sooner than December the 16th, because we did run into a glitch, and had it come up in September or October, we would have had ample opportunity without changing the meeting to make it earlier for Geranium's convenience, which I didn't mind doing, to do that. So I just wanted to comment on that. That's kind of the impression I got. It was that every expectation was that council might just simply move forward with approving this particular document. I think the exercise today was very, very important. And once again, I don't have a problem with the development. I don't have a problem with Street A, but I will say that merely finding something in the agreement that referred to access to Snow Valley Road in the agreement and for this exchange of $350,000, I have to say, I didn't know that that property was the property that they were alluding to be quite frank with you. And prior to that, seeing Street A on any development plan, unfortunately, unless it was defined in a different color that showed that it was Springwater Township property, I'll have to plead ignorance because nobody pointed it out to me that, hey, this is a piece of property that the township has, and we're going to utilize it for Street A. So I have to say that maybe it's ignorance on my part, but it would have been nice to have been apprised of the situation. It would have been nice for staff to approach council prior to negotiating or suggesting the $350,000. I think they did it in the best interests of township. However, as a corporation, I see this. I mean, I'm a representative of the residents in Springwater and certainly the residents in Ward 1. But as a corporation, we are the board of directors. I hear that every once in a while. And as the board of the directors, we have an obligation to the township residents who are our shareholders to make sure everything is on the up and up and we're satisfied before we move forward. And if anyone doesn't agree with me, I wish they would speak up. So I do thank everybody for the exercise. It'll certainly make moving forward on the next one a lot easier. Thank you.
Thank you. Mr. Engel?
Thank you, Mr. Mayor, and I apologize to council for any lack of clarity and confusion in terms of the process that we followed. And I hope we've laid it out fairly for you now. And Mr. Mayor, if I could just have a brief indulgence for something aside, and that is these are challenging times for everyone. But I wanted to acknowledge that for all of those of you in public service, council and staff, this has been an extra challenge beyond what any of you thought you might be dealing with in this term of council. And I think it's important to acknowledge that and thank you for that. So I wish you all have a happy holiday season with your loved ones as best you can in the circumstances. Thank you.
Thank you very much, Mr. Engel and Mr. Mullen. Certainly do appreciate this session that we've had and all the work you've done up to this point. Councillor Cabral? You're muted.
Thank you, Mayor Allen. There was one point I did want to touch on, and it's basically with respect to the complexity of this particular agreement and the negotiations that resulted in this agreement coming forward at the OMB, because it was through the agreement that the OMB decided to move forward with the rezoning. Part of the decision, which I found kind of interesting, was point number 18. And I'd just like to read this so we get an idea that this, I don't think, was your standard let's move forward deal. By the time all final adjustments were made, the draft conditions were, brackets, in the words of one expert planner, quotation marks, more onerous than anyone would typically see, and even a double sort of control. The list of supporting studies was 3 pages long. The proposed zoning bylaw amendments, the draft plans of subdivision, and the associated conditions of approval appear supported by technical studies, including environmental impact studies, functional servicing studies, addressing water, wastewater, and stormwater management, servicing, transportation, assessments, and archaeological assessments. And I'm only reading that because when I read it there, it really struck home as far as maybe this was a more complex and not quite what we might consider a standard contract and agreement that came before us moving forward. So just to let staff know, and legal counsel and Mr. Mullen, I understand the complexities, and that's why I struggled with it so much.
Okay, thank you very much. All right, if there are no more questions, comments, then I need a mover and a seconder to approve the report regarding the mixed stage 2 subdivision agreement. Councillor Ritchie. Oh, is Councillor Ritchie? You're still muted. There.
Hello, can you hear me?
Yep.
Mayor Allen, just before we move on there, I just want to reiterate what Councilor Cabral is saying. I'm not here to hold up moving forward, but it's the way that, I guess the way it was done, and I that raises a concern with me. I'd say going forward, it'd be nice for us to be kept in the loop. That piece of property there, that entranceway, I thought, and I remember speaking about that to someone there a little while ago, that it would have been nice to add that on, take that land and make a bigger public works department. And the response that I got from the person, I'm not going to mention names, was, well, we can't do that because of the hill. Here all along, there was already a deal made, and oh, okay, so it's fine. It was made in 2014. I'm not going to hash this out. We need to move forward. But the setting of the price and agreeing on that, that could have came before council. That's what disappoints me in this whole matter here. And I would ask, and you know, it raises a question. I'm going to be honest with everybody. Like, it raises a question. If you did that, what else have you done that we don't know about? That's the whole thing. Councilor Cabral is right. We are the board of directors. We make the final decision, not staff, us. So we're not here to throw sticks in the mud and hold everything up. But, you know, if you're making those decisions without us knowing, that's not good neither. And you're going to get some pushback on that.
Okay.
Down the road, anyways.
Thank you.
So, anyways, but before I'm done, I want to know what you think, Mayor Allen.
I think that we've gone through this agreement. There's a lot of history with respect to it. It's a good agreement, and we paid for specialist help through Mr. Engel and Mr. Mullen. They've been through the agreement. We know more about it now. I think that we should sign the agreement and move on. Can I have a mover and seconder to deal with this motion? Councillor Moore and Councillor Maude Chapman. That report from the Director of Planning regarding SU 2012-04 Mixed Subdivision Agreement Authorization Report dated December 16, 2020 be received, and that the Mayor and Clerk be authorized to execute the subdivision agreement substantially in the form attached as Appendix D, Draft Stage 2 Subdivision Agreement, which is to be registered against the subject lands mix to permit the installation of sanitary, storm, and water main sewer pipes and site works associated with the treatment plant lands as per the terms of the draft subdivision agreement, subject to the advice, review of township solicitors, engineer, and staff. Before we vote, Councillor Cabral, you're muted.
Thank you, Mayor Allen. Just when you started to read it, I remembered that was something I wanted some clarification on. The very last bit there, the last couple of lines with respect to the motion. Could you just read them again? I'd like to get a better understanding of what that review and advice means, because council's voting on it now, and I just need to know if it's going to be substantially changed after council votes on it, because that clause does kind of permit that. So could you reread the last line so council hears it one more time, please? And then maybe Mr. Engel and Mr. Mullen can just give us a little bit more insight on that.
To permit the site works associated with the treatment plant lands as per the items of the draft subdivision agreement, subject to the advice, review of the township solicitor, engineer, and staff. I think it's referring to the advice and review that we have received thus far from our professionals, Mr. Engel and Mr. Mullen.
That would be great if they would just concur with you. I'd be happy with that.
Mr. Engel?
Yes, Mr. Mayor, thank you. That's the reference I made to the substantially in accordance with. If you approve this today, we know what authority you've given us, and working only within that authority, we would dot the I's, cross the T's, make sure the whole thing hangs together, that we don't have typos or, references that don't go to the right place. We don't think we do, but that allows us just to clean it up. If there's something more important that comes up or the developer wants, slip that in, we won't do
Nope.
it. We would
Thank
bring
you.
it back to you.
Thank you very much. I guess I'm from Missouri, and that's why they call it the Show Me State.
Okay. All those in favor? Opposed? That is unanimously carried. Thank you. And thank you again, gentlemen, and happy holidays.
Thank you, Mr. Bear.
Okay. Can I have a mover
Merry
and seconder
Christmas.
to move into closed session, please? Councillor Cabral and Councillor Moore, that in accordance with Section 239 of the Municipal Act 2001, the Corporation of the Township of Springwater does hereby resolve to move into closed session at 3:46 p.m. for discussion pertaining to a personal matter about an identifiable individual, including municipal or local board employees, or labor relations or employee negotiations, the topic being the retirement and recruitment of Director of Public Works. All those in favor? That is carried. I'll give a moment for Clerk Ainsworth to go into closed.
I do want to make mention that I was happy to see Deputy Mayor Coughlin joining us for these meetings. Missed her absence.
Thank you, Councillor Cabral. I will be back. I am back. I don't have to go back down until the 15th of January. So we've received some better news, and we're just gonna keep on keeping on until then. So thank you.
Will I have time to open my Christmas presents, Clerk Ainsworth, or should I hold off?
What happened to Speedy Michael?
Yeah.
My apologies, it'll just be a moment.
And you have the motion, do you, that
Thank you, Mayor Allen. You may proceed.
okay, so you're going to read the motion in open, please?
Yes, thank you. The motion would read that council directs staff to release a posting for the position of General Manager, Infrastructure and Operational Services in lieu of vacancies for the positions of Director of Public Works and Director of Recreation, Parks and Facilities.
Can I have a mover and seconder for that, please? Councillor Ritchie and Councillor Moore, all those in favor? That is carried, thank you. A mover and seconder for the confirmatory bylaws, Councillor Cabral. Deputy Mayor Coughlin, that the bylaw 220-112 to confirm and adopt the proceedings of council, the special meeting held on December 21 listed herein be signed and sealed by the mayor and clerk. All those in favor? And mover and seconder for adjournment, please, Councillor Ma and Deputy Mayor Coughlin, that the Springwater meeting of the Township of Springwater, special meeting of the Township of Springwater does now adjourn at 4:45 p.m. to meet again at regular meeting on January 20, 2021 at 6:30 p.m. All those in favor? That is carried. Thank you, council, and stay safe.
Stay
Merry
safe.
Christmas.
Merry Christmas.
Christmas.
Boom.